Good morning, and can I welcome everyone to this, the 23rd meeting of the Standards Procedure and the Public Appointments Committee in 2025. I've received apologies this morning from Emma Roddick, and so can I welcome Rona Mackay, who is attending as committee substitute. Good morning, Rona. Our first item is to invite members to agree to consider items 4 and 5 on our agenda in private. These items relate to consideration of the recommendations of the Scottish Parliament Gender Sensitive Audit and to guidance on the Code of Conduct. Are members content to take that in private? Yes. I'm grateful. Our next item is to take evidence on the Freedom of Information Reform Scotland Bill. So can I welcome Katie Clark MSP, who is member in charge of the bill, and she's supported today by Carol Ewart, Director of Campaign for Freedom of Information in Scotland. Can I thank you both for joining us this morning? I understand, Kate, you'd like to make some opening remarks, so can I pass over to you?
No, thank you very much. And I'd like to thank the committee for the opportunity to allow me to appear today, but also for the work they're undertaking to scrutinise this member's bill. And I'd also like to take the opportunity to thank all of those who've engaged with this member's bill process in both of the consultations. Those that have attended events, have met me to discuss the bill and have taken part in this committee's proceedings. In particular, I'd like to thank Carol Ewart from the Campaign for Freedom of Information in Scotland, who's worked with me throughout this process, and the Information Commissioner and his office, who've worked with us on some of the details. The bill attempts to bring together work carried out over a number of parliamentary sessions and the recommendations of the 4 Information Commissioners who've been appointed since the 2002 Act. It's therefore a set of specific technical proposals which have considerable support, but also a provision to give the Parliament a power through its committee system that could lead to a parliamentary vote to designate a body. It includes recommendations from the Public Audit and Post-Legislative Scrutiny Committee's review of the 2002 Act conducted in the last parliamentary session, including the introduction of a pause-the-clock mechanism and recommendations to ensure the proactive disclosure in a more systematic, accessible format for the public. Successive Information Commissioners have consistently recommended modernising FOIS's operation, including expanding FOI coverage to more public functions, improving record keeping and information management, and enhancing the Commissioner's power to ensure compliance. This bill is also a recognition that there have been rights lost in many sectors due to outsourcing. My member's bill seeks to reflect on the practical recommendations that have been made, and we've attempted to respond to issues raised by stakeholders in the progress of this bill, and this is reflected in the bill which was lodged. I have had a number of meetings with the former Minister during the bill's progress, and obviously both Carol and I are happy to answer any questions.
Yes, thank you for that, Katie. Thank you. As convener, I'm going to grab the opportunity to kick off, and I think you've already discussed the recommendations that came out of session 5, and you've also talked about how all of the commissioners who've held that role have indicated shortcomings that they've identified. I suppose on a personal level, are you a bit disappointed that it's required a member's bill to deal with this?
Yes, this bill was taken forward as a result of frustration that there had been a failure by government to act, and it was Carol Ewart from the Campaign on Freedom of Information in Scotland that asked if I'd be willing to take forward a member's bill after a great deal of lobbying to try to get the government to come forward with recommendations.
Absolutely, and we are obviously at the tail end of this session. And certainly when you've attended some of the evidence sessions, you've already pointed out, do you want to put sort of formally on record your concerns about the time that's available left within this session for your bill?
Well, I am concerned. I think I'm in the same position as a number of members' bills. I don't think that's the fault of any individual member. Unfortunately, the Parliament isn't geared up at the moment to provide support for members. I would have preferred if the bill was before the committee earlier in the parliamentary session, but my view is there's still time. As I say, I have met with the government a number of times during the progress of this bill over a number of years. However, I haven't really had feedback until the submission that was made to this committee last week, I have had a great deal of feedback from other stakeholders, and we reflected that in the drafting of the bill. So the original bill, that was a draft bill that the Campaign for Freedom of Information in Scotland originally presented to me, has been amended quite substantially to take into account the views of stakeholders, including those that could be designated under this bill, and indeed the Office of the Information Commissioner.
That's very helpful. And I mean, the Scottish Government have identified a number of areas: the duty to publish, the creation of an offence, and the resourcing implications, and whether or not these can all be addressed. Do you have any concerns about that, or do you think that we have received sufficient evidence to make conclusions and draw conclusions? I'm going to speak about the financial memorandum in my next question. It's really just the areas that the government have identified, saying, if I précis it, these are really big and we need time to think. Do you think that is a legitimate concern, or do you think that your bill, as currently drafted, or as you've understood in the evidence, if it were to proceed, would be amendable to encompass any concerns?
So if I focus on the two issues that you've specifically raised, proactive publication is something that's been argued for over many, many years, and has been recommended by information commissioners and others who are stakeholders in that they work regularly with freedom of information. And it's also based on what's happened in other jurisdictions. So the view is that the way that the 2002 Act was framed with the best of intentions, but the reality is that the publication schemes have not worked, and that the proposals that have come forward have been developed over many, many years, and indeed have a great deal of consensus within those that are interested in these issues and engaged with these issues as a more effective way of taking the matter forward. So in particular, all four information commissioners support the proposals in the bill, and we have come forward on the basis of consensus, if you like, with all the stakeholders that were engaging, and they tend to be people that are quite actively involved in FOI. In relation to the new offence, I mean, I heard the evidence last week. This is something that is in addition to offences that already are on the statute book, as we know, are very, very rarely used, and it is hoped to have a deterrent effect. It is an offence that is being put forward as a result of a specific set of circumstances. And again, it would be envisaged, it would hopefully never be used, but would be there as a deterrent, but is basically dealing with a loophole that has been discovered. And again, this is a proposal that has the full support of the Information Commissioner's Office, and indeed we work with them and on other parts of the bill to make sure they were drafted in such a way that were workable for that office.
Thank you, that's helpful. And if I turn to the financial memorandum and then pick up about the duty to publish, you've articulated, as the evidence you've just given now, as really a reframing of an existing anticipation, the place to get to, and therefore have suggested that it's effectively cost neutral because we're moving on. The government don't agree with you on that. What is your evidence, what is your view about the fact that this positive publication is simply a reframing of an existing duty and therefore already encompassed within it? Or do you see that the government may have something in that the evidence that we've heard about the changes that may be required, particularly within councils, could occasion resource?
Yeah, so the policy intention behind the bill is not to add costs. And as you will be aware, the existing 2002 Act doesn't require anybody to create any new information. It's simply to provide information that is already in existence. But the intention of this bill is to effect a culture change with proactive publication. And the view is that that will reduce costs. The committee will have heard that this bill in itself doesn't automatically lead to any new designations, but obviously if there were new designations, they also would require to conform to proactive publications. The view is that both the proactive publication but also the codes of practice that would come from the Information Commissioner would make it very clear to organisations what they require to do to comply with their duties under proactive publication. But that obviously would only apply to information that already exists. I know the Information Commissioner spoke last week about perhaps some of the consequences that could flow that may lead to organisations providing information in a different way, so there was more of a standard data format. And I know that's something that probably every committee in this Parliament would recognise as an issue. But the Act itself, as you know, doesn't actually require new information to be provided. And hopefully proactive publication would make it easier for the public to get information, would reduce the number of FOI requests, but also would ensure that any FOI requests are actually cheaper.
So you're going on the fact that, as you made the point in your introduction, this actually is a technical bill,
yes, rather
than massive new grounds.
Yes.
And that actually the financial memorandum is accurate in that really you're reposing an existing obligation. But you did talk about it trying to achieve cultural change. And we all know that cultural change is incredibly difficult to achieve. And invariably does come with costs. What's your view on that specific part of it?
I think a large part of the cost of this bill will lie with the Information Commissioner, and that has been fully costed into the bill because it would be their main role. They would be the main driver of the implementation of this bill. There are many in the FOI community that would say this bill wouldn't cost anything because it simply requires organisations to do what they should be doing anyway. So, for example, on training, there's already a statutory obligation on public authorities to update training on a regular and annual basis. And some would argue that this bill shouldn't require any more money because that work should be happening anyway. We haven't framed the financial memorandum on that basis, and we recognise that the way that organisations will respond will vary differently, and some will spend a huge amount of money trying to implement this bill and others not. And that's why the role of the Information Commissioner is so important in terms of the Code of Conduct, to make it really clear to organisations what they require to do to comply with this legislation.
And that, in essence, would be your thesis to the question that new designations would cost money. Actually, the work that the Information Commissioner has done when there is a new designation, unless that individual authority or entity wants to spend a fortune, much of the work will already have been done. It will be presented to them as a step, and actually they shouldn't fear that designation, because if they're a well-run organisation, they can comply with it easily.
The only new designations that would automatically take place as a result of this bill would be the Section 3 new designations, publicly owned companies. In relation to those companies, you can already make an FOI request, but that FOI request would have to be made to the public body that owns that company. We therefore would hope there would be savings, because it would no longer be necessary to go both to the parent body, who would then have to retrieve the information from the publicly owned body that would have to provide it, and then it would be provided back to the member of the public or the person who'd made the FOI request. So we would hope that that would involve savings. However, the way that we've drafted the FOI memorandum, the financial memorandum, we have looked at those organisations and we've costed in that there may be a cost for that organisation, but we would hope that would be a transferring of cost from the organisation that owns it. In terms of new designations, the evidence that the committee will have heard, and indeed the evidence that's been put before me, is that there is a very wide range of views and evidence on the cost of an FOI application, and the amount that different organisations spend. It varies tremendously. that sometimes it is said to do with the efficiency of the systems that the organisation has and the amount of resource that they decide to put into FOI compliance. The policy intention behind this bill is to reduce cost, and we would hope standardisation and the Code of Practice would reduce cost. However, we recognise that when there's a new designation for a new body, and it could be very large bodies that we're talking about, that there would be costs for that body, and we've outlined what those would be in the financial memorandum. In general, those would not be direct costs that would be borne by the Scottish Government. They would be costs that would be borne by the new body. That body, for example, might be a multinational, it might be a third sector organisation or a charity, it could be a private body, for example, it could be a privately owned care home if this Parliament decided to go down that path. But these are all matters that would be looked at by the Parliament when the Scottish ministers came forward with a recommendation for a designation, or indeed if the Parliament decided to use the mechanism proposed in this bill.
That's very helpful, thank you. Ruth, can I turn to you?
Yes, good morning. I would like to ask about access to information held by public authorities and then further powers to designate Scottish public authorities this morning, Katie. Both in terms of the presumption in favour of disclosure, both the Scottish Government and the Information Commissioner told committee that existing legislation and the Code of Practice already support that happening. So why does this require amendment in legislation?
So you're absolutely correct. The existing legislation requires this, and indeed international law requires this, but the reality is the system isn't working well, and the way that the legislation was brought forward in 2002 hasn't worked in the way that was envisaged, and those that are actively involved in the sector believe that a proactive publication duty and very clear codes of practice and guidance from the Information Commissioner about what that actually means would be a far more effective method, and indeed is a way that it's done in other countries, which seems to be successful.
Okay, thank you. In terms of designating the further powers to designate Scottish public authorities, you've described your approach as proportionate and a proportionate report. Respondents to our calls for evidence and witnesses in here have spoken about designation pace being slow. We obviously heard reflections from the government on why that was the case, but I think probably overwhelmingly the response that we've had uses language like glacial and things like that. How will your proposal speed up the pace of designation?
We would hope that if this bill became an act, that the Scottish Government itself would deal with these matters more speedily, and that would in itself speed up designation. We'd even hope the discussion taking place today helps to speed up the process of designation. However, as you know, there's also a new mechanism in the bill that would allow a parliamentary committee to get involved should it choose to do so. So if I use, for example, the care example that's currently being looked at by the Scottish Government may come forward in the next Parliament with proposals to designate the care sector or parts of the care sector as to be FOI compliant. If the Scottish Government failed to do that, you can imagine that might be quite a big political issue, and a committee of this Parliament that would likely to be the Health and Social Care Committee may decide to use its own time to look at that issue, and it could put out a call for evidence, it could take evidence, it could hear all parties, including the Scottish Government, including the sector, including the campaign groups, come to a view, and it could make a recommendation to the Chamber that could debate the issue. Obviously, that would require changes to standing orders to enable that to happen. But it would require a committee of this Parliament to decide that they were going to use their time in that way. So it's likely only to happen when it was a big political issue. And I would hope that the fact that the Scottish Government knew that there might be that enhanced scrutiny where ministers failed to act would help to drive designations.
Can I also just
add
in some information, please, to the answer? The presumption in favour of openness has really got to be emphasised, because what's been happening is unsatisfactory. The statistics that are produced by the Commissioner shows that 75% of requests result in all or partial information disclosed. So theoretically then, but practically if the bill is passed, that would mean that that kind of information could be proactively published. The model publication scheme currently is not working, and the kinds of classes of information, and there are 9 that are in the model publication scheme, are really relevant to the kind of FOI requests that people routinely make. For example, how we take decisions and what we have decided, what we spend and how we spend it, how we procure goods and services from external providers. Now, if the 9 categories were published the way that they're supposed to be under the model publication scheme, we would not be talking about proactive publication now. It's because it's not happening, and that is a cultural issue. And when the Dundee Courier came out in favour of this bill, they were very explicit in saying that the legislation needs to also change culture, and that's something that we would certainly endorse. Moving to the issue around designation. Designation has been glacial. That's why an alternative...
Apologies, can I just interrupt you, because we are conscious of time and we have a lot to get through. This session is for the member, and I know you like to support, and I know a substantial amount of what you've talked about has been submitted in evidence, and we have it within that. So it's really just, I'm conscious that we want to hear from the sponsoring member in relation to this, because we're also trying to establish the amount of room that we have if this matter goes forward about where changes are needed, rather than the evidence that which we've already got. But thank you for that, that contribution.
That's helpful.
Sorry, Ruth, can I come back to you?
That. Katie, can I ask your assessment of the root cause of the delays in using Section 5, and can you speak to how your bill addresses these root causes?
Well, I think that's a bigger question, and it's not a party political question about why it is that maybe governments don't always act as quickly as they could. And I suppose they're listening to stakeholders from all sides, and there are always pressures not to act as well as pressures to act. So it's very difficult for me to really explain why decisions aren't taken to act, but I presume it's because it's complex. But you've heard evidence, for example, with stock transfer. If we look at historic examples, when council houses moved from council to housing associations and other bodies, there was a loss of rights, and it took many, many years, I think 13 years, for those rights to be brought back. We know in many sectors there's been a loss of rights. So, for example, when there was outsourcing in the justice sector, rights were lost. You know, there's no sign of those services coming back into, you know, being run by Scottish Government. So rights have been lost, and there haven't been the political decisions to ensure that those rights were maintained when those services were transferred. So we have the situation, as you've heard in evidence, that ScotRail is now back in public ownership, and because it's now back in public ownership, we've got our FOI rights, and actually it doesn't seem to have been significantly onerous for that body, as indeed the housing associations and other bodies that are now required to comply with the legislation are receiving a relatively small number of requests.
Okay. Why do you believe there needs to be a statutory obligation to formally consider proposals made by the Scottish Information Commissioner?
I think it strengthens the position of the Information Commissioner. And my view in terms of the operation of this bill, that helps drive the intentions of the bill, which is transparency, accountability and openness. And of course, part of the reason for that is about ensuring a better use of the public pound and better public policy. Thank you.
We spoke a little there about parliamentary committees potentially being able to designate. I'll just have some more questions on that. I think you've covered why you think it's appropriate. I don't know, you can add more if you wish to on that. The proposal requires consultation before passing a resolution. You'll have heard the Scottish Government raising concerns about how proposals would be initiated and how Parliament would assure itself that consultation was adequate. What process do you envisage for initiating resolutions and ensuring that robust consultation?
Well, in general, it's a matter for committees themselves. It could be that there would be detail and standing orders. That would be an option in terms of this process. But in terms of ensuring a robust process, it's the transparency of the process that will ensure whether it's a robust process, and obviously all stakeholders. So that would include, the sector. If it saves private bodies, it would involve those bodies and their representative bodies. All stakeholders, including the Scottish Government, would have the opportunity to make representation. So it would be a far more transparent, and I would argue public process that perhaps might be a more robust process because of the scrutiny of it being in public. But it would be an additional mechanism to the Scottish Government. It wouldn't be instead of the existing mechanisms.
Thank you. That's helpful to get that on the record.
Yeah.
Well timed. Sorry. How long do you think a designation should take?
I know
that's a really hard question to answer.
It's a hard question because sometimes it might just be one body that's quite a small body that might employ, a relatively small number of people, not involve considerable amount of money, but for political reasons or for obvious reasons, it may be that the Parliament takes the view that it should be compliant with FOI, or it could be a massive sector. So I think it's difficult to say because I think it just depends on the proposed designation, how much evidence would be involved and the complex nature of it. Yeah.
The reason I ask is that unless either through standing orders or some other method, committees have a procedure that can be started, processed and decided, we could end up in a situation that we do with post-legislative scrutiny, where lots of committees would love to get to it and actually have a genuine interest in it, but because they have so little control of their own timetabling, it would never come about, and therefore we would have a solution that's never actually used and would occasion an ongoing frustration, which at the moment is aimed, quite frankly, towards the Scottish Government and the glacial pace. But we would then turn that onto committees who have no way of fulfilling that requirement. So really just your thoughts on that.
That would be a matter for the committee system, and I fully recognise the points that you make. And it would be presumably where it was seen as a political priority by the committee. So in the aftermath of COVID, care homes may well have been considered a political priority and may well have been an area that would be identified by a committee of this Parliament to launch an inquiry into, whereas an area that maybe there was less public attention on, it's far less likely that that would happen. So that is an additional mechanism, and it's something that's available. It will strengthen the role of Parliament to hold government to account.
Do you see it, and you've emphasised that it's additional, do you actually see it as also acting as an angel on the shoulder of government to make sure it accelerates its role with regard, as much as another process by which designation could happen?
Very much so.
That's helpful. Sorry, Ruth, I didn't mean to cut across.
It's okay. Specifically on the Section 5A resolution, can you clarify your intention on timing and whether standing orders would need to be amended to provide certainty? And that's in reference to Scottish Government evidence about uncertainty when a legal change would take effect.
So is this the report to Parliament, the Section 5 report to Parliament?
5A,
yes.
I believe, is the debate in Parliament when Scottish Minister reports the use of Section 5 powers to designate new public authorities.
Oh, so it's the designation of a new body. Yeah. Well, the whole purpose of this section, and indeed the whole bill, is to increase accountability and to drive designations. And in specific reference to these reports, it's to drive awareness of designation of bodies and create the parliamentary space, if you like, for that discussion to take place. So the policy intention is to incentivise the greater use of the Minister's power to designate, And of course, the intention of the 2002 Act was always that bodies delivering public services would comply with freedom of information requests. So the report would be a regular opportunity to review the Scottish Government's work to
Thank
deliver
you.
that.
Katie, I'll pause you there. I've maybe not been clear
Right,
in my
sorry.
question, forgive me. So the uncertainty is about when the legal change would take effect under the Bill's Section 5A resolution.
So, and the legal change that you're referring to is the designation of a body.
Designation, yeah.
Yes, I think this would have to be. So this is the designation of a new body as falling on from a vote by Parliament. Yes. So I think this is the kind of detail that would have to be put into standing orders. I don't think that would be appropriate. On the advice that we got was that it wouldn't be appropriate for that level of detail to be put on the face of the bill.
Okay.
And I think that, and it may well be, it would differ from one designation to another. So if it was a body where there was a view that the designation had to be speedy and it was a relatively curtailed matter and that it was a relatively discrete matter, it may be the view would be that implementation could be within a very short period of time. It could be for other matters, it would be different. And I think that would have to be laid out in the proposal that was put before the Parliament.
So it would be, you would envisage it being within the standing orders rather
It could be within the standing orders, and it may be something that the committee itself would look at, because if, for example, it was a large sector that the committee was looking at, it may have a view in terms of an implementation timetable. If it was a single body that was a relatively discrete matter, it may take the view that that could happen either immediately or very, very quickly, say within a month or 3 months or 6 months. So I don't think necessarily it would be appropriate to put that on the face of the bill, because I think it would depend on the designation. Sorry.
Yeah, I think it might help in the sense that obviously standing orders can't direct when a legislation, however, the motion that would be debated in the Parliament could articulate the date that it takes effect, because that's where the Parliament are. I think the question rests in a sense that is that the vehicle that you see the designation occurring through, rather than the designation being by the Minister and then subsequently reviewed in this debate. You see the actual role of Parliament in that motion as the vehicle of designation.
Yes, and it would depend on the framing of the motion that was put before the Parliament. So it may depend on the circumstances, and there may well be occasions where or indeed that might be part of what Parliament is debating, and there may be different views. Different political parties might take different positions about how speedily something could happen. There may be an agreement on the principle, but some may say, well, this will take longer to implement, and others may say, no, we want it done now, and that would be the kind of matters that would need to be debated. But I think in reality, how quickly you could designate and how quickly the order could be implemented would depend on the nature of the designation. Yes. So it would be unwise to have a standard rule, if you like.
On the requirement to debate the Scottish Minister's Section 5 reports, this mechanism, do you see it as a way to provide additional scrutiny? Do you envisage that it will speed up designation of bodies?
That's the hope. The reason that I was asked to take the bill, and the reason that the bill has come forward, is partly as a result of a frustration of the glacial progress in new designations. So the hope would be that if there was this debate as a standing matter that the Parliament considered, it would put the issue higher up the agenda and would lead to more designations, as probably ministers would want to be able to say in that debate that they had plans and this is what, this was their intentions, and would give, if you like, commitments to the Parliament that you hope would be honoured.
Okay, thank you, that's helpful.
Annie, can I come to you?
Thank you, Convener. Good morning, Katie. Good morning, Carol. My questions to start off with is about requesting information in Section 6 of the bill. And I just wonder if you can confirm that the proposal in correspondence addresses is intended as a technical amendment, a technical clarification, that an existing position on email addresses would be sufficient for a valid request, and how would you respond to the Scottish Government's view that the current drafting may not make it clear enough that an electronic address alone is acceptable?
So that has very much been the intention behind the section, and it's been drafted on that basis. And it's been drafted, again, this is a very technical amendment that has been included because what we've attempted to with the bill is to bring together all the different changes and recommendations that have been made where there seems to be a strong body of support and consensus almost. And this was one of them. So it's been drafted by parliamentary draftspeople, and this is the drafting that they felt was robust. We have had alternative versions, but this was the version that we were advised was appropriate.
Yeah, and obviously the second part of my question was like the Scottish Government's view is that the drafting may not make it sufficiently clear. And do you think that has made it clear enough now, or do you think there's more work that needs to be done with the Scottish Government to make it clearer?
The advice I had was that it was sufficiently clear. However, I am open to amendments. It's a technical amendment, and if there was a view that it wasn't belts and braces, then obviously there will be scope for amendment, and we would be very amenable to discussions.
Thank you for that. And sorry,
jumping in and apologise for this. But your intention was that an email address should be sufficient.
Yes.
It doesn't need to be an email address and a postal address.
No, just an email address.
Thanks for that, for clarification, Convener. And my second sort of a port of questions is time for compliance and the pause the clock proposal. The Information Commissioner suggested that an alternative model for the time for compliance provisions to allow a short initial period of clarification requests, after which any delay would be deducted from the response time. Why did you decide not to adopt this approach, and what's your views on its merits or otherwise?
So the intention behind this proposal is to speed up the process and encourage early clarification, and has come from those directly involved in the process. So again, I would view it as a technical amendment that there seemed to be a consensus from those that are heavily involved in freedom of information on, including the Information Commissioners, academics, the campaign, and those that use freedom of information regularly. It was also something that was looked at by the committee in the previous Parliament. I don't know if Carol would want to add anything, because it's a technical point that has been raised.
As you quite rightly point out, there is discussion around it, and on balance it was felt we had to keep it simple for the public to understand. And the pause the clock is a concept that people readily understand, and that was really why we came down in support of it.
Perfect. Thank you very much for clarification on that. And my final question, Convener, if I may, it's on the repeal of time for compliance regulations for grant, aided and independent special schools. And just why do you believe that the 2016 time for compliance regulations create inequalities for freedom of information rights?
So I will bring Carol Ure in on this, if that's all right, because I know that she's done a huge amount of work on the issue. Carol.
So, Annie, it didn't make sense at the time when it was passed by Parliament, because going back to my previous answer about keeping the legislation simple so that the public can understand readily, it's 60 working days is the maximum response time for independent and special schools, and 20 working days for state schools. And we in the Campaign for Freedom of Information could never understand why there was that disparity. Some of our most vulnerable children are in special schools, and it didn't make sense. The problem has been exacerbated because of the UN Convention on the Rights of the Child Scotland legislation, passed in 2024, and therefore we believe it's untenable. And the human rights impact assessment that we're required to be presented with the bill makes that point. But it's working days. It's the difference between 20 working days and 60 working days. So if a private or an independent special school is closed, then it wouldn't apply.
Right. Okay. Thank you very much for clarification. Thank you. Thank you, Convener.
Thank you. Thank you. Sue, can I come to you?
Yes, you can. Thank you, Convener. This section of questions, Katie Clark, are on enforcement. and the Scottish Information Commissioner, because there's a number of sections that have got some technical updates around the powers of enforcement. So in section 9, you believe that a new exemption for information provided to the Scottish Information Commissioner during the investigation of appeals is necessary. So I was wondering why you thought that.
Yes, I think the Information Commissioner spoke on this last week and used some real examples. And the intention, obviously, is to ensure that the person seeking the information gets the information that they're entitled to, and this is to enable the Information Commissioner to assist in that process. And I think, therefore, having an exemption is appropriate to enable the intentions of the legislation to be delivered. I think, the Information Commissioner spoke about real examples last week.
And you were here last week, so we have heard the Scottish Government believes that as drafted, the exemption is not limited to the FOI request made by the Commissioner in respect of the information held by him. It's their view that under the Bill's proposal that once information is provided to the Commissioner, it becomes exempt even if it would not previously have benefited from an exemption. So how do you respond to those concerns that this could allow the original authority to rely on that exemption to withhold the same information in response to other requests?
So the section obviously refers to a section in the 2002 Act, which is section 47(1), and it is a narrow set of circumstances that apply. So it's where a person is dissatisfied with a notice and that there's been a failure by a Scottish Government to which a requirement for review was made to give such a notice, that the application is made to the Commissioner for the decision whether in any respect specified in the application the request for information to the requirement relates has been dealt with in accordance with Part 1 of this Act. So it's a very narrow set of circumstances
So has it been your intention that the exemption should apply only to the Commissioner? And do you think, therefore, that there may be some provision should be amended to really make that much more clear?
Our view was that it was clear on the face of the bill, and it's information provided to the Commissioner and only to the Commissioner, and that information has to be in a certain set of circumstances that's outlined in 47(1). I think this is based on practice experience, that this becomes an issue, and this would assist the Information Commissioner in their work. If this exemption was allowed, and on that basis it seemed a reasonable request from those that have worked in the Information Commissioner's offices.
Thanks, Katie Clark. In section 10, we're looking at amendments to section 43, which sets out the general functions of the Scottish Information Commissioner. And I think there is a part where you consider it necessary to have a statutory power to require individuals, rather than just the public authority, to provide information where it is necessary for the Commissioner to perform its statutory functions. Is that?
Yes, that's correct. And they're agents of that public authority. They are normally employees carrying out a specific function of that public authority.
Okay, thank you. In section 11, so this is a bit of you can see we're going through the various sections here. Section 11 proposes repealing section 48A of the Freedom of Information Scotland Act, which currently prevents the Scottish Information Commissioner from investigating how its own office handles information requests. So what was your rationale for removing that specific restriction?
I think it's for consistency, and the view would be that there would be a firewall. So it would be for greater accountability and a consistency in terms of the implementation of the legislation. Is the thinking behind it? Is that? And Carol's pointing out to me that other regulators investigate themselves, so it's not a new approach. It would fit in with that general principle.
The bill also, as introduced, doesn't provide for the repeal of sections 48B and C which prevent the Scottish Information Commissioner from investigating the handling of appeals about the handling of information requests by the Procurator Fiscal or the Lord Advocate in the Lord Advocate's capacity as head of the Criminal Prosecution and Investigation of Deaths in Scotland. So why was the repeal of sections 48B and C not included in the bill, even though this was also recommended for consultation in this session 5?
The reason that some things have been included and some things haven't been included has really been on the basis of trying to get a consensus. So I may well have wanted more things in the bill that I've not put there, but what we were trying to do was to come forward with proposals where there was less controversy, if you like, and that there seemed to be more of a consensus amongst stakeholders. And I think this is one of the areas. This is one of the areas where there was less consensus, but also issues raised about legislative competence. And therefore the view was it probably was better not to go there in terms of including it in this bill. There were quite a number of matters we could have included in the bill that we haven't because we thought they may run into problems and there would be different views. So we've attempted to coalesce the proposals round about areas where there's a broad level of support.
Yeah, indeed. It was the Scottish Government that indicated last week that there may be issues with the legislative competence of including the Procurator Fiscal and the Lord Advocate. So,
yes. And there's obviously these are issues that could be raised at stage 2.
Yeah, thank you. Section 12 in the policy memorandum of the bill, you've indicated that the use of enforcement notices to require compliance with the codes of practice should be seen as a last resort. And the Scottish Government has additionally indicated to us that it's got concerns that making the codes of practice enforceable would give them the status of law. So why do you consider it important that a practice recommendation can ultimately be enforced?
Because we've got to give power to the Information Commissioner in the way that was outlined in the evidence last week, that if the Information Commissioner has powers, all the evidence seems to suggest that that acts as a deterrent and ensures that bodies comply with the requirements of the Information Commissioner. So it's an effective policing, if you like, of the bill. So in relation both to the matter that you've just raised, but also the offences, both in the 2002 Acts and indeed the new offence proposed in this bill, they're very much in place, not because we believe that they would be used regularly, we'd hope they'd never be used, but as a deterrent and to give power to the Information Commissioner. And I know he used a specific example last week where he's used the powers that he has to ensure that there's compliance before having to go down the formal steps. And indeed, I think there was another example of that in the newspapers this week.
Yes.
So giving the Information Commissioner powers hopefully means that they don't have to be used, but they ensure that public bodies comply with reasonable requests that are being made and lawful requests that are being made.
That specific example you're referring to, we've received correspondence from the Commissioner on that very subject. And yes, it has been widely covered in the press this week, you're correct. In section 13, this is the Prime Minister's, sorry, I'm the First Minister's veto power.
Yes.
And why do you believe that the veto should not be retained, even in a more limited form suggested by the Scottish Government? Of course, the Scottish Government last week stated that they wish for it to be retained, so you're in different positions.
Well, of course, that was the first time that we had a detailed response from the Scottish Government. So we've not really been able to take their views into account. There has been a consensus that because the power has never been used, that it should be removed, and that in terms of public trust, it's inconsistent to have that power in place. So these at the end of the day are political matters, but there has been proposals over many, many years that this power should be taken away because it's not needed.
Because we did hear some examples from the Minister last week that I think, and I think there was national security, but there's other mechanisms.
There's other ways. The examples that were used would all be covered in other ways. It may be if they could come up with some more examples. I'm not suggesting they might. I can't envisage why it would be required. But obviously, if the Scottish Government have very strong views on that, this is a matter they could put forward at stage 2. But I think that the evidence that we've taken and the views from stakeholders is that that this is not required, and there's very, very strong support for its removal.
Yes, and to a lot of the optics and the trust and respect. Yeah. I understand that. Finally, in section 14, Katie Clark, the Information Commissioner has explained to us at the committee that late compliance with decision notices has resulted in unnecessary expenditure for its office. If a public authority ultimately complies with the substantive requirements of a decision notice, even if late, what practical benefit would pursuing enforcement through the courts for late compliance deliver?
I think it's very similar to the other examples that have been put to me. This is another provision that is intended, hopefully will never be used, but will be a deterrent and will help drive organisations to deliver on their legal functions and statutory obligations.
Bit of the behaviour change and culture you were referring to.
Exactly, yes. So it's hoped it wouldn't be used, but there may be extreme cases where the Information Commissioner felt that they really, it would be in the public interest for this matter to be taken forward.
Thank you, Katie Clark. Thank you, Convener.
Rona, can I come to you?
Yep, thank you, Convener. Good morning.
Thank you.
Good morning, Carol. I wanted to ask you about the bill stating that you feel there's a need for a new Scottish Information Commissioner power to share information with Audit Scotland. Am I right in thinking this would be an extension of already existing powers? Because I think to some extent that does happen.
Yeah, if it's okay, I'll bring Carol Hewitt in on that one.
Thank you for the question, Rona. And in fact, it was reported this week that following the Scottish Information Commissioner's ruling on a particular local authority about them abolishing a job without any paperwork to substantiate it, Audit Scotland took some action itself. So there is an impact of matters being reported in the press. I think it was really a determination that freedom of information should serve the public sector as well as the public, and that if the Information Commissioner does come across information that they think will be relevant to the functions of Audit Scotland, who are managing the public pound on our behalf, then there should be that explicit duty. So,
but if I understood you correctly, he already did that, so he has that power anyway.
So it wasn't clear that it was the Commissioner that referred it. It was what was clear was it followed on from the Commissioner's public statement on the website. The Audit Scotland did that, and I think it's more explicit. You know, it helps to understand the rules in advance, and for example in legislation, and for the public to be reassured that there will be that flow of information. It's a bit like child protection, isn't it? When lots of different silos are collecting information, and it's only when they share it that they realise that there's a pattern and action required.
Okay, thank you for that. Katie, can I ask you, replacement of the publication scheme duty with duty to publish for public authorities. So, as somebody relatively new to scrutiny of the bill, I found that quite, mind-boggling, a bit confusing. So, in effect, does that mean that you're wanting them to be more proactive?
Yes.
Is that what that sort of means? Because if they have a duty to publish anyway.
Yes. The hope is that the bill will lead to culture change where more information is proactively published. And as the Information Commissioner outlined last week, in the codes of practice, it would outline the type of information it would be useful for an organisation to publish, and the Information Commissioner would work with the organisation in relation to this. It is also hoped that this would lead to a reduction in the number of FOI requests, and therefore there would be savings as a result of that cultural change, because information would already be readily available. And the Information Commissioner's office said that often it's readily you can often predict the kinds of FOI requests that are going to be made, and if that information was proactively published, then there wouldn't be the need for the public to rely on the FOI mechanism.
So on the issue of savings, some local authorities and including a university
Yeah.
have said they would need more money to do that.
Yeah.
What's your answer
Well,
to that?
the intention is a cultural change rather than requiring organisations to get new staff. That there isn't a policy intention or a wish that organisations get more staff to perform the function. It's
No,
more
but
about
if it's
how
set in
existing.
statute, if it's legally, if they're legally required to do it, they might say, well, we can't do it unless we get more staff, and that's going to cost more money.
So the 2002 Act only requires information to be provided that already exists. So there wouldn't be a requirement to create new information, but there may be a requirement working with the Information Commissioner over time to publish information that already exists in a more readily accessible way automatically before there's a request.
Okay. So Scottish Government not happy with that part of the bill, and they fear it could have unintended consequences to mean that local authorities are obliged to publish all information they hold, and the bill doesn't specify any limits on that. Would that be something that you would think could come in at stage 2, or do you think it needs to specify limits?
I think that would be clear in the publication code that would be produced by the Information Commissioner, and those information codes would be sector or indeed maybe perhaps even organisation specific, and the view would be that it shouldn't be onerous. And it will be dependent on the resources of the organisation. It's about the culture change, not about putting additional resources into the functions. It's about how people use the time, and there's obviously there would be a consultation process leading up to the publication code. So therefore, to use the specific example that you've cited of local authorities, which are a large and significant set of bodies, then there would be quite an intensive, I would imagine, consultation process with local authorities about what might be in the publication code.
Okay, thank you. Thanks, Convener.
Thank you. I want to turn to the designation of a Freedom of Information Officer. And we've seen there's been a lot of support for that, but there's also been evidence to say that it's unnecessary. One of the challenges appears to be that the designation clearly needs to be high enough within an organisation that can be made, but the work of freedom of information is frequently done by staff at a much lower level. How are we going to get over the challenge of holding a designated official responsible when internal documents will suggest everything has been designated to a lowly person and it's gone wrong and it's their fault? So how do we make sure that the designation actually works at the level that I think you anticipate it to be, that there can be cultural change driven by a senior person without the blame just being poured down the ladder to someone else?
So this proposal comes from FOI officers themselves and is something that's been discussed over many, many years and long before I became involved in this issue. Often Freedom of Information officers are also data protection officers, so they are able to see how that function operates, and that has a statutory basis, and these provisions have been mirrored on the provisions of data protection legislation. And what FOI officers are saying is that when they're also the data protection officer, the organisation complies with the law and the requests of that official. But when it's freedom of information, because they don't have the statutory authority, it's very difficult sometimes for them to get their organisation to comply with the legislation. And they believe that if they had the same statutory footing as they do as a data protection officer, then they would be able to perform their functions better. So that's the rationale behind this. And if somebody is often a data protection officer and an FI officer, I can't really imagine that there should be a grading issue in relation to that. So the policy intention is not for the creation of new roles, although we have obviously had to put detail of that within our financial memorandum. The policy intention is to give more authority to those that are already doing the work, which hopefully would lead to savings, because when they make a request, it will be complied with, rather than them having to perhaps go through an extended and lengthy process before information is released. So it's to empower those that are attempting to deliver on the 2002 Act.
So the purpose behind it reflects effectively the success that data protection officers have brought to the system with freedom of information. I mean, I suppose just as a by-question, we have heard evidence that actually, if you then include records management, you're bringing together the three areas that are crucial to this and probably crucial to the cultural change that you've referred to. Did you consider effectively within the bill merging those three roles?
No. No. I think what we've attempted to do is to bring together concepts and proposals that have been on the table for quite a lengthy period of time. So therefore, there may well be other things that could have been included, but what we've attempted to do is to coalesce around the areas where the Campaign for Freedom of Information in Scotland and other bodies and the Information Commissioner are in agreement. So I think, you know, I appreciate the Scottish Government are taking a different view on some aspects of the bill, but in terms of the stakeholders that have engaged with the process, then what's in the bill isn't necessarily what everybody wants, but is what everybody is comfortable with.
And again, one of the things that we've heard some evidence about is that very small organisations may struggle to provide that sort of different role. But actually what you're suggesting is it's a role that sits very complementarily with the data protection role, for which there aren't exclusions, so someone has to be responsible for that. So actually the resource implication is very small for that designation because it's probably the person who's doing it anyway.
Yeah. In larger organisations, that would definitely be the case. In a very small organisation, and there aren't that many very small organisations that need to comply with this legislation, but in a small organisation, it might be the chief executive that would have that responsibility.
That's very helpful. The last part I want to do is to really just talk to the offences that have been suggested and considered, and we've heard lots of different evidence about this. You've talked a lot in the evidence that a lot of these steps are actually hopefully never going to be used. They're directory to change that cultural. Do we need to create another offence just to change the culture and the approach to freedom of information?
Well, this is a specific offence that's being proposed that comes out of a specific set of experiences. So it's a defined set of circumstances, and I would argue is a gap in the legislation. And as I know that you will be very well aware, Convener, the threshold is a high threshold in terms of a criminal conviction of beyond reasonable doubt, and there would be it would be necessary to prove intent, that somebody intended to alter documents with the intent to prevent disclosure. So it would be a high threshold. We would hope it would never be used, but it would make it clear to government and to officials that if they thought a FOI application may come because it was self-evident that that was highly likely that that material should be protected.
And are you also comfortable with the unusual circumstance where time running doesn't run from the event but runs from the investigation? So in essence, it doesn't run from the destruction, it runs from, the 3 years would run from the investigation. So unlike many offences which are occasioned by the actual act, this is not occasioned by the act. The actual time running comes from the investment. Now, it may be inevitable because of the circumstances that we're talking about in this offence, but
the time would run from the point where any reasonable person, and perhaps everybody, would be of the view that it's likely that there might be a freedom of information request because of the nature of the material and the nature of the issue. That would,
is that not the challenge, though? Because a reasonable person may think it runs from the date something went into the shredder, whereas the facts of it don't come out till a few years later, and the time would then run from that investigation. Is my understanding of the...
So, I mean, it may well be at the time that information is destroyed that it wouldn't have been reasonable for that person to believe that this was going to become a massive issue 5 or 10 years down the road. And they, in those circumstances, you know, there wouldn't be a case to take through the courts. It is envisaged, and it's been framed on the basis it would be in exceptional circumstances that this offence would be used. And as we know from the existing offences that exist, and indeed are framed in very similar terms, this is mirrored on existing offences that have been in place for many years, but extends to the situation where records are altered at an earlier stage before an FOI application is made. And we know from those other offences that they've been very, very, very rarely used, although we've worked on the basis that they will be used once or twice a year in our financial memorandum. In reality, that is very difficult to conceive.
So one of the other criticisms of it that's been levelled is it's hardly ever going to be used, but potentially local authorities will now have to store forever and a day information because they're concerned that at some point in the future someone's going to come along and say this person deliberately got rid of it. How would you answer that?
I think the Information Commissioner dealt with that very well last week, and the Code's publication will make very clear, it will be made very clear to say a local authority what information they require to keep and or to publish, the threshold is high, so it would have to be an extreme set of facts that led to the decision by the Information Commissioner to try to seek a prosecution, and then the Crown Office obviously would have to take a view. You can imagine it would be an extreme set of circumstances where it would be felt in the public interest to take a prosecution of this nature.
And my final question, I'd be glad to hear this, my final question in relation to this is over the Scottish Government's concern about the commencement, the specific commencement of this, because of the need for everyone to understand what's potentially going to happen with regard to this new offence. Have you got any views at the moment about an extension to the commencement for it, or is that something that you hope between discussions that if we move to that stage before stage 2 can take place and that you're open to?
Well, this is a criminal offence. So the set of circumstances that are likely to lead to the Information Commissioner and the Crown Office wishing to proceed with an offence would probably be such that the view would be that it's appropriate that the legislation is in place. So I'm not sure exactly the nature of consultation that would take place in relation to the criminal offence. I can understand there may be a need for consultation in relation to proactive publication and the type of information that's published, but in terms of the destruction of records, then I would have thought that the threshold is so high.
Let me ask it a different way then. There is no intention for a retrospective criminal offence for events that occur before the commencement of the Act took place, irrespective of the fact that the time may run from the point of the start of an investigation.
No, this is not a retrospective piece of legislation.
That's fine. Thank you. Unless anyone else on the committee has it, that's excellent. Carol, Katie, can I thank you for attending this morning? If you have thoughts or views that come to mind, as sometimes happens the second you step outside of the door, you know where the clerks are to reach us, and vice versa. Should we have any questions further to our deliberations, I hope you don't mind us outreaching to you for answers. And so can I thank you very much for your attendance this morning at committee. And I will suspend the public part of our meeting today.